Okay, if Bank of America purchases Countrywide, are the banks considered, or are the notes considered sold? Uh, it wouldn't matter. It has nothing to do with anything. The Hey guys, no side talk, okay? Because it messes up everything else. That it, it it wouldn't matter, okay? The the bank can do business the way the bank wants to do business. That does not concern you. And if you worry about that, you will misstep in all of your legal pleadings and how you operate in court. It's none of your business. If I sell my car to Mike, is it any of your business what's in there? No. Don't worry about what the bank does. It's none of your business. The note, the only thing that you're concerned about the note is whether or not you have to pay for it. Now, you don't have to pay for it because the bank made the decision knowingly, intelligently, willfully, with full knowledge of the consequences thereof to discharge you of the obligation, because if they don't, then this $1 million note is only $1 million to them. But by discharging you of the obligation, they can sell it and get $27 million. Here's your choice. Would you rather have $1 million or $27 million? You don't really need to answer that. That was rhetorical. So that's just how the banks operate. So the rest of it's really none of your concern. I wouldn't worry about it.
My question, real quick, is with the substitute. I'm going back to the substitution of trust. I know that
Okay, it's a substitution of trustee, not a
trustee.
substitution
I
of
meant to
trust.
say trustee. Um, I'm going back to that because I was told that we could also we can send them a letter to say cease and desist, or do not continue with the fraud and return everything back to normal. I was wondering if you are agreeing with that.
I think you can send them any letter you want. I don't think it'll do you any good.
Okay.
Okay. How many people here are familiar with administrative remedies? How many people have had them work? Okay, then. Letters don't work. And I don't spend much time with them. Now, there's nothing wrong with sending a letter to evidence their bad behavior. I'm all for that. Send them a letter saying, why are you an asshole? I don't think they're going to respond. But if you send them a letter and say, stop being an asshole, and they don't respond, now you've got something. Do you understand the difference? So, it's like, hey, quit doing this to me. And they don't stop. When you inform somebody they're doing you wrong, and they go ahead and continue to do you wrong, that's what's called willful intent under the law. And that takes it up to a different level. When you look at criminal acts, there's mitigating circumstances. When somebody knows what they're doing is wrong and they do it anyways for what we call pecuniary gain, which means just because it's profitable, it takes it to a next level. I'm all for sending them letters as long as they're correctly written, as long as you're saying what they're doing wrong. Are you getting my attention? What? Oh, okay. Oh. Uh, uh, as long as you put something in there that be somewhat explicit on what you're trying to say, which I'm not doing a very good job of. But you don't go like insulting them. Don't go threatening them. Don't go questioning them. Tell them, hey, stop doing this. Now, you may want to send them a letter requesting documents or evidence, or why are you doing this to me? Can you give me a reason why you're doing this to me? Now they got to respond, and they won't. Well, can you put that in the court? Absolutely you can. Judge, I've tried to settle this matter privately without wasting the court's time. Now, okay, I am going to tell you a trick that was told to me by a judge. Write this down. Nobody will tell you this anywhere. No lawyer will agree with you. No judge will agree with you. You are not supposed to know what I'm going to tell you at any and all cost. If you have the letter delivered by a process server, the court is involved. From that moment on. Now, no judge wants to acknowledge that. Can't do anything about it. No lawyer will ever admit to it, but they know it's true. A process server is an officer of the court. When the process server delivers that letter, it's delivered by the court. That's it, guys. And that's a real big deal. No. A notary is a public officer. A process server is an officer of the court. Now, there's a lot of authority when instead of filing your own documents, you have your friend that's a notary go in there and put him in court. But when you're talking about the administrative remedy, okay. If you were to do an administrative remedy using a process server instead of a notary, who's doing the administrative remedy? Oh, yeah. See? You can't be half right in this shit. You can't be half right. Okay? You know, the administrative remedy could be highly effective done with a process server because that's the court delivering it. That's not just some public officer. Okay. I'm going to jump back for just a second. You hear all these guys. I've been kicked out of the official league of guru idiots or whatever you want to call it. Because they're always talking about, oh, there's public and there's private. There's not public and private. You know, your bedroom's a pretty private place. The government's in there now. Like, and I'm not going to jump off on a tangent because I don't care. But like gay marriage. Now, I'm a very devout religious person. You can't really tell by my behavior, but I am. I don't really care. I don't think gay people have done something so incredible that they should be denied the torture of marriage. So I don't get it. I just don't get it. Why should we protect them in particular? I don't get it at all. So, your bedroom's the most private place in your life. It really is. Well, next to the bathroom, and it depends what kind of shape you're in. So, can the government step in there? Yes. There is no public and private. There has never been any public and private, and there will never be any public and private. What there is there's commerce and bankruptcy. And when you talk about public, when you take what all these guys are saying about like administrative remedies, and you throw out the notary and you use a process server, now you've jumped into court. That's some power. And when you take everything that they say about the public and you replace it with the word bankruptcy, something will start happening. It'll actually, their insanity, which they have an abundance of, will start making sense. And then when you take private and replace that with the word commerce, and you do that with all the documents they have out there, it'll start making a lot of sense. For those of you that are into that garbage, it'll start making a lot of sense. Okay, you had a question over here. Patrick, hold on, guys. Up front, please. Now, we have to break every hour and a half because of a battery issue. Kind of like dating when you're young, but we won't go into that.
Is it on? John, just
Yes.
going back to that original question that that lady had about filing these substitution of attorneys with the
No, substitution of trustees.
substitution of trustee, right? If the homeowner was of the belief that they have this right to do it, after all, they're referred to as the trustor, the mortgagor, the grantor of that trust, and we know what they did with that money.
Okay, but your presumption's incorrect. I know where you're going, but your presumption is based on the fact that the deed of trust is valid. Is the deed of trust valid?
But what I'm saying is that at the time they
Doesn't
do
matter.
this, they don't know, and they're relying on the knowledge that they do have, and what they do know is that they are the trustor of that trust that was created by that contract that they signed.
Ignorance of the law is no excuse. Not it's a pretty good excuse, or it's a really bad excuse, or on Tuesdays we can use that excuse. It's no excuse. That will not fly. Most criminal law cannot be absent willful intent. Say that again. Most criminal law cannot be absent willful intent. In other words, you have to be purposely committing a crime to be prosecuted. That means you've got to define purposeful, you've got to define intent, you have to define a whole lot of words. Was the crime still committed? Was a false or fraudulent document filed in a public office?
I understand it commenced at the time it began.
Doesn't
There was
matter.
a
Then your
beginning.
reason for doing it or your belief is not. As a matter of fact, in a court case, the judge would not allow you to discuss your belief. It would not be when you talk about criminal law, I don't want to jump too deep into criminal law other than you need to understand this for how you're going after the banks, and that's the only reason I'm discussing this. When you jump over into criminal law, all right, in civil law we have what's called a preponderance of the evidence. That means anything above 50%. Does not mean 78%, does not mean 63. It's anything above 50%. That's a preponderance. When you jump into criminal law, you have to reach beyond reasonable doubt. Well, the reasonable doubt is only incumbent upon whether or not the act was committed, not upon your belief, not upon your intent. Now, jump into jurisprudence on that real quick. There was, for a long time in this country, in criminal law, this concept that doesn't come from the Constitution. The concept you're innocent until proven guilty. You realize that's not anywhere in the Constitution? It's not. It's like the separation of church and state is not anywhere in the Constitution. The concept of innocent until proven guilty came out of a Supreme Court case. That onus probandi was reversed a long time ago. American jurisprudence in criminal now operates on the theory you're guilty until proven rich. That's it. You can argue with it. I do it every day of my life. You're guilty until proven rich. So, when you're talking about, let's cut to the chase. Was the crime committed?
I'm seeing two criminals here, and what I'm
No,
and
no,
how
no,
I'm
no.
understanding
See, you can't do
this.
this in court, and
well-
you're never going to understand this.
Well, so are you saying that the only way to resolve the matter is to take this to the court? Because these homeowners who are actually filing the substitution of trustees,
They're all gonna go to
believe-
jail.
Well, no, they believe that they are within their right.
There's nothing. Belief doesn't matter. There's people that believe that
So
there's a not a very old religion in the United States called Jehovah's Witness. I've studied most Christian-based religions to one point or another. Jehovah's Witnesses have a concept about blood.